Angie, you may call the next case, please.
Terrance S. Roberts et al. Versus Kentucky National Insurance Company et al.
Good afternoon, Your Honor.
Afternoon.
Drayton Berkeley for the appellants. I'd like to reserve 5 minutes for rebuttal.
5 minutes. All right, sir. You may proceed.
Thank you, Your Honor. May it please the court, this is a case here on a motion to dismiss, which might be a misnomer based on the rationale being put forth in the briefs. Kentucky National, well, the basic fact is, in this case, the court is well aware what the standard is for a motion to dismiss under 12b-6. The trial court is authorized to dismiss if there's no set of facts where the plaintiff can prove his claim. The heart of this case, evidently, is an appraisal clause which was not complied with, and a refusal to pay for some cash value amounts, investigate personal property, and mitigation costs. That is the breach of contract claim we're alleging. Now, why is this case ripe for adjudication? The appraisal clause was triggered because the appraisers met on February 22nd. They could not agree on an umpire. This had to be, the agreement had to take place within 15 days. That was not accomplished. Therefore, that made this case ripe for adjudication. The complaint was filed well after the 15-day period, and it does not foreclose Kentucky National's right to challenge the appraisal award based on either coverage or causation under our law in Tennessee.
So is your claim a claim for breach of insurance contract?
Yeah, the underlying claim is a claim for breach of insurance contract based on the failure to comply with the appraisal clause, number one, failure to pay mitigation costs, failure to investigate the personal property loss, and failure to pay undisputed cash, other undisputed cash amounts. So the underlying claim is a breach of contract, and we stack, obviously, on top of it, a punitive damages claim, and then there's a potential claim for unlawful insurance act.
And so why are these other defendants named if your contract is only with the insurance company?
Well, the other claimants are dependent on how this court interprets the Unlawful Insurance Act. The Craighead case stated that that claim applies to everybody, but other courts have interpreted it to mean that it only applies to the claimants in our situation. So,
Again, what's your cause of action against anybody if it's a contractual claim other than the other party to the contract?
if the claim is limited to contract, then the other parties go free, because
Why would it not be if you're asserting a contract claim?
because we also inserted Unlawful Insurance Act claim that's considered a tort claim.
And how does that apply to you based upon the plain wording of the statute?
Well, the plain word of the statute is slightly is a little confusing. The Craighead case, which this court issued in 2008, if I'm not mistaken. Yeah. July 1st, 2008, said it applied to everyone. Now, if that means what it says, then there's a tort claim that's operative against all of the defendants. If this court says it does not mean that, then there is no Unlawful Insurance Act claim. That's the basic, basic statutory interpretation says that, as the court has alluded to, that we take the plain words of the statute to be enforceable as written. But there's also law that says that if there's a judicial construction of the statute, then that becomes operative in the statute. That becomes part of the statute unless the legislature or another court says that is incorrect. So that's where we are. We are in a quagmire legally as to whether Craig had amended the Unlawful Insurance Act or not. If this court says yes, then those claims, tort claims under the Unlawful Insurance Act apply to everyone. If this court says no, and the Tennessee Supreme Court says no, then it does not. Those claims are gone. It's just a straight breach of contract claim against the insurance carrier, punitive damages claim against the insurance carrier, potentially if those facts are borne out in discovery and deposition and trial, and if a jury agrees with us. So that's the question we're here for the court. We brought the issue here for disposition. I don't have to recite to obviously this body what the Tennessee construction of contract principles are. The court is well aware that's been plenty of opinions, and a lot more knowledgeable than that than some, just old country lawyer like me. And I won't bother the court with all that other stuff.
I noticed that this matter was certified under Rule 54.02.
Yes.
Is there anything remaining in the trial court?
I do not believe so, because if I'm not mistaken, the dismissal of the Unlawful Insurance Act would also apply to the other defendants as well. And although they weren't disposed of, disposition of that claim will dispose of everyone except for Kentucky National.
Okay, and there are at least, as best I can tell from the record, 3 people or 3 named defendants
Yes.
that were never served.
I don't know if they were served or, that fact I'm not certain of. They might not have been served, Your Honor. Now, the brief for Kentucky National states that the appraisal claim was not ripe because there was some other technicality that should have happened. If the claim is unripe, then that means there's no subject matter jurisdiction. That means that the matter should have been dismissed without prejudice under Rule 12.02 for lack of subject matter jurisdiction. If the court, in this case, rules that it was improperly certified under Rule 54.02, then the result is, under the Rich case, is that the case should be vacated, the underlying order should be vacated and remanded.
Well, if there's nothing remaining in the trial court, there's no reason for it to be certified under Rule 54.02.
Say again, Your Honor?
If there's no claims remaining or no parties remaining in the trial court, then there's no purpose in certification under Rule 54.02.
Well, I imagine that's correct procedurally.
So it's a question of, it's either a final judgment or it's certified appropriately under Rule 54.02 for this court to have jurisdiction.
Could you restate that again, Your Honor?
The court it either has to be a final judgment.
Yes, sir.
Or it has to be certified appropriately under Rule 54.02 for this court to have jurisdiction.
Yes, sir.
To consider the claim or to consider the appeal.
Yes, sir. But I believe it was properly certified. That was the argument. That was a response to the court's July 26, 2024 show cause order.
Understand. And I think we decided we would defer that to the panel.
Yes, sir. That's where we are. Mm-hmm. We're here. Let's see. We got 55 seconds left. But we believe the case of Holmes versus Shipp if we're talking about certification, it set out some factors. It was an August 2nd, 2024 opinion of this court that came obviously after everything, after the appeal had already been pending and filed. It set out some factors, relationship between adjudicated and unadjudicated claims. Obviously, the adjudicated claims were the claims against the named defendants and some individuals, but not all of them. I don't have to list the factors, the court obviously knows those.
Let me ask you, the Kentucky National argues in its brief that you did not meet the necessary conditions in order to file your lawsuit. What do you say about that, and what pleading can we look to in your complaint to show that you satisfied that contract before filing your lawsuit?
You mean all material conditions of the contract? Is that what the court's referring to?
Before filing a lawsuit, yeah, there was a provision that you had to satisfy before filing your lawsuit.
I think that's implicated in the facts that we pled in the lawsuit. We said that the appraisal had already started. The appraisal had already started, and we get to selection of the umpire, that's when everything broke down. I think that those facts satisfy that condition of the lawsuit. I don't recall whether we expressly.
And you plead that where in your complaint that you satisfied those conditions before filing your lawsuit? I mean, what paragraph in your complaint do we look to show that you complied with that before filing your lawsuit?
I'm not certain it's expressly stated that way, Your Honor. I don't think so. I'm not certain. I have to go back and look myself at the complaint to make sure. But I know pretty certain that we pled with regards to the only claim, breach of contract claim there is about appraisal. We stated the facts sufficient to satisfy that condition.
Okay.
You've got your rebuttal time, Mr. Berkeley.
Good afternoon. May it please the court, Elizabeth Bass. I'm here for Kentucky National Insurance Company and its two adjusters who participated in adjusting this claim, Jeremy Spencer and Alan Faber. Ms. McKinney is here for some of the co-defendants, sub judice appellees here, and so I'm going to allow her some of the time toward the end. I understand I can't reserve time.
How much time are y'all splitting time?
Yes, that is the plan. We did not have a specific.
Well, we're gonna need a specific.
Yes, Your Honor. Would you like 5 minutes? 5 minutes.
10 and 5, Miss Angie.
All right. To be efficient with my time, I want to start with the appraisal clause of the policy that Kentucky National issued to the Robertses. I'm not going to read it to the court, that's in the materials, but I do want to discuss the procedures that it requires before a suit can be filed against Kentucky National. It requires that a party who is dissatisfied with the appraisal, or not the appraisal, excuse me, with the estimates, the value of the claim, if they can't reach an agreement, either party can invoke the appraisal clause, and from then they have to select in writing an appraiser to serve on their behalf. The other party then has 20 days to select an appraiser. After the appraisers have been selected, they must agree to an umpire, who is yet a third person who acts in resolving the dispute over the value of the claim. If they attempt to do that and fail to do that, then either party can petition a court of competent jurisdiction to appoint an umpire to act as the tiebreaker. Whether the appraisers are able to agree to an umpire or whether the court has to get involved to appoint an umpire, that is not the end of the appraisal process. From there, the two appraisers visit the property, prepare their estimates, they exchange their estimates. If they agree, if they reach an agreement as to the value of the claim, then the appraisal process concludes. If they do not reach an agreement, essentially the umpire serves as a tiebreaker, and that's the end of the appraisal process. Only once it gets to the end is the claimant, is the insured, authorized to file suit against the insurance company. That's a condition precedent, as is made express in the policy of insurance. The complaint does not aver that all conditions precedent were met either by the magic language or by virtue of the facts that led up to the filing of the suit. The averments are that the plaintiff selected an appraiser, and implicitly that Kentucky National selected an appraiser, because it does state that they made contact. There is no averment that they made an effort to select an umpire and could not reach an agreement. Even if that had been alleged, the next step would not be to file breach of contract and tort claims against Kentucky National or anyone else. The next step would be to petition the court for appointment of an umpire. That is included in the complaint that is the subject of this appeal. However, it is our position that by not following all the steps before that suit is appropriate, the plaintiffs did not meet the requirements to file their suit for appointment of an umpire. For that reason, we believe all the claims were properly dismissed. No claim has been stated because the condition precedent to the contract has not been met, as is apparent from the face of the complaint.
Let me ask you, that language in paragraph 21 of the complaint that says that the insurance company breached the contract by refusing to participate in the mandatory appraisal process or comply with its policy provisions after proper demand by the plaintiff. Is that not sufficient to put at issue the selection of an umpire? And of course, the lawsuit is part of the relief, which the plaintiff has a right to do under the contract, file a lawsuit to have the trial court determine an umpire, right?
Eventually, yes, if an agreement could not be reached. However, there is no averment that they attempted to reach an agreement and that they could not. And in fact, if the court considers, I believe it's Record on Appeal, page 42, which is Exhibit 5 to the complaint, the only information we have about any efforts to communicate between these two appraisers is in an email dated March 17, 2023 from Alan Faber, one of my clients. He works for Kentucky National. He says, based on his information, the appraiser, Kentucky National's appraiser, was unable to get a response from the appraiser chosen by the insured. So what has happened is the plaintiff's appraiser would not participate in the process. And this is incorporated into the complaint by virtue of the plaintiff's own filings. I didn't put that into the record.
How come this isn't a motion for summary judgment as opposed to a motion to dismiss?
Because it fails on the face of the complaint, Your Honor. Even if the court concludes that it was appropriate to file the portion of the complaint that seeks appointment of an appraiser, let's say that's the court's conclusion. Filing suit as to the breach of contract claim and the tort claim for unlawful insurance act was not appropriate. Completing the appraisal process, which goes all the way through evaluation of the claim and submission to the umpire if the appraisers can't agree, has to conclude before those claims can be brought.
But what I'm trying to ascertain is what evidence did the trial court have in front of it about the conditions precedent to the invocation of the contract rights?
It did not need evidence. It had to assume that all the averments of the complaint and the attachments were true pursuant to the standard for motions to dismiss. But the face of those averments does not state that all conditions precedent were completed.
Let's assume that they do.
If the complaint did say that all conditions precedent were completed,
The complaint could be construed reasonably so that those conditions were pleaded.
then that would not be, the failure to meet a condition precedent would not be a basis for dismissal. However, there are other grounds to dismiss. As the court's aware, the obligation is not to just look at the conclusory averments about, recklessness or legal conclusions about someone breaching a contract, but at the facts that underlie those claims that are pleaded in the complaint. Those do not meet the requirement for breach of contract, and I'm running short on time, so I'm going to skip to the next, but it is brief. The averments of the complaint do not, the facts that are pleaded show that Kentucky National selected an appraiser, attempted to communicate to select an umpire, and that did not happen, investigated the loss by sending multiple adjusters to the scene, and followed its own procedures in attempting to resolve this claim. And so I will move on now, however.
Let me ask you, looking
Yes,
at
Your Honor.
paragraph 16 of the complaint, the plaintiff alleges that after the appraisers were selected, they've not been able to agree on an umpire as provided for by the policy.
It does say that they have not been able to agree. It does not reflect that any effort was ever made to agree, and the only documentation or any information about that is in that email from Mr. Faber that says their appraiser was not communicating with Kentucky National's appraiser. And so the risk here,
Can you even consider that email?
yes, Your Honor, attachments to a complaint can be considered in consideration of a motion to dismiss.
It can be considered as an attachment, but there are some, the information contained in that email may be objectionable on another basis.
I believe the plaintiffs incorporated those into their complaint by virtue of attachment and their references to them.
Not disputing that, I'm just trying to figure out what evidence, the same question I had a moment ago, is what evidence did the court have in front of it on the motion to dismiss, and why that wasn't converted to a motion for summary judgment?
I understand. I hope I've answered the question as to our position on the purpose those emails served. I'm happy to answer more questions.
That's all right. Go ahead.
Gonna have to get my brain back on track, excuse me. I did want to switch to, I apologize. The risk of not requiring a plaintiff to plead that an effort was made to select an umpire is essentially what happened here. A claimant, an insured, can simply elect in writing, invoke the appraisal processes, nominate their own appraiser, and then do nothing. They can tell that appraiser, don't communicate with the other side. They can refuse to participate in good faith. If all they have to do is appoint their appraiser and then wait 15 days and file suit, the purpose of the appraisal clause has not been met, because the whole purpose is to avoid litigation if there's a way by which the parties can reach an agreement or a resolution that's satisfactory to everyone.
But if in their complaint they allege, and of course this is kind of vague, that the insurance company did not comply with the provision for the selection of an umpire, can you, based on that pleading alone, on a Rule 12 motion, get the complaint dismissed?
If the factual averments that lead to that are not adequate to support all the conditions for seeking approval of an umpire.
You know, out of the pleading rules, it's got, I mean, it doesn't require a lot of specificity, but I mean, you could read this to mean that the insurance company didn't follow the procedure. I mean, that's what it says, didn't follow the procedures. I don't know that it requires the specificity that you're talking about. In any event, if it's dismissed because you show that the conditions in order to file a lawsuit have not been met, would the complaint be dismissed with prejudice?
Meaning the contract and tort claims as opposed to just the
contract claim.
umpire?
Yeah, do you get that
umpire.
dismissed with prejudice?
No, I don't think so, because the insurance policy says that you have to complete those procedures. And then if you, at the conclusion of the appraisal procedures, if there is still a dispute, that's when filing suit on any other claims would be ripe.
Okay, so a dismissal at this point would not be with prejudice then?
I think that's right, Your Honor.
Okay.
My time is up. I'm happy to stay up here as long as you'll have me. All right.
Thank you.
Thank you.
Good morning, Your Honors. My name is Kelsey McKinney on behalf of Defendant Crawford and Company. I'm just going to run through with my 5 minutes just briefly Crawford's position. Crawford's position largely aligns with Kentucky National's. However, since most of Kentucky National's argument was spent on the condition precedent issue, I'm going to go through the rest and Crawford's view.
Is there anything left in the trial court to be adjudicated?
As to Crawford, it is...
As to any party that you're aware of, specifically as to your client, though?
As to Crawford, no. The only thing that arguably would be left in the trial court is the fact that one of Crawford's adjusters, Dustin Richmond, was named as a defendant in the suit and was not served. However, under Tennessee Rule of Civil...
What does that mean?
That the case was never commenced against him. And so it's our position that since the case was never properly commenced against him, that the adjudication in the trial court was final as to the defendants that had been properly served, that the case had been commenced against. As to plaintiff's breach of contract claim, it's Crawford's position we were not a party to the contract, and that under Tennessee law, even though we were an independent contractor of Kentucky National, that does not create a contractual liability into Crawford because agents of insurers are not parties to a contract of insurance. As to the request for punitive damages, it is well settled that punitive damages are not generally available for breach of contract claims. As for the punitive damages issue, or not punitive, the treble damages issue, the only available remedy for violations of the statute that is alleged in the complaint, the violations of the Unlawful Insurance Act, TCA 5653-103, lays out the remedies that are available. Excuse me, I think it might be one of 7 that has the violations actually laid out. But treble damages is not included. Treble damages is only included in 102, which is about criminal liability, not civil liability. And 5653-108, I believe, states that the remedies outlined in the statute are the only available remedies. As to the Unlawful Insurance Act, it is clear on the face of the statute that that statute moves in one direction. It's about actions taken by the insured to the insurer. It does not go the other way around.
What about the case that Mr. Berkeley alluded to? So
in Craighead, it does not stand for the proposition that 103A1 applies to anyone who commits an unlawful insurance act. In fact, it only is involving a question of an insurer's statutory immunity for reported suspected TennCare fraud to law enforcement under a different provision of that statute. That's 5653-110. So it's Crawford's position that that case does not apply to the facts here. And notably, even if it were to apply, the court found that the insurer was immune from liability. So addressing the breach of contract claim, the punitive damages claim, and the Unlawful Insurance Act claim, on the face of the complaint, all 3 of those were not adequately pleaded as to Crawford, and as such, the request for an appointment of umpire should also be dismissed because there would be no justiciable controversy as to the liability of Crawford. Crawford's not liable under breach of contract. Crawford is not subject to punitive damages, and Crawford is not liable underneath the Unlawful Insurance Act.
Thank you.
Thank you.
Mr. Berkeley, I believe you have 5 minutes.
I don't think we'll take the whole 5 minutes, Your Honor.
I've heard that before.
Well, court asked a question that was answered when I made arguments at the University of Tennessee, Memphis, before this, not exactly this panel, but Judge Stafford was here. It was answered in the case of Belton versus City of Memphis, whether the court had to provide notice, whether it was going to convert a motion to dismiss to a motion for summary judgment. That answer was in the affirmative. It had to provide notice. There was no notice that this matter is going to be converted to a motion for summary judgment. Therefore, we operate under the standards under Rule 12b-6. Now, Judge Armstrong asked a very interesting question to Kentucky National Council, which was answered in which I thought was very positive for the appellants. He asked whether this matter, if it's dismissed at this stage, should it be without prejudice, and Kentucky National conceded that, which is basically what they said in their brief, unripeness. And I think Crawford and Company said it as well. If the claim is unripe, those are subject matter jurisdiction issues. Unripeness, mootness, political question. Those matters get to whether the court has the power to adjudicate the claim or not whether the complaint states the claim, which is the argument they made was under the wrong rule, is my argument. If they were going to proceed that we didn't meet this, that, or other precedent, then there's a subject matter jurisdiction rendering the case unripe. Therefore, the claim should be dismissed. Now, if the court finds that it was improperly certified, then that gets us back in the same place. It's the September 28, 2023 orders vacated and remanded, and we go back to zero, which is essentially the same place we would go back to if the court finds that subject matter jurisdiction, if the claim is unripe. The court finds that the 12b-6 motion was improperly granted because the complaint states enough subject material, and I believe Judge Armstrong pointed this out as well. The pleading standards are not what are required in federal court. Federal court requires a pleading of plausibility, a whole lot of additional facts that are not required in state court. As a matter of fact, the Webb Court, Tennessee Supreme Court, rejected the federal pleading standards back in 2011, so we still deal with the any set of facts issue. And we believe we've met that standard in this case for application to the appraisal clause, application of the damages. Therefore, we think that on all set of circumstances, this case should be reversed and remanded to the trial court or the trial court order should be vacated and remanded to the trial court. And therefore, we think if the court chooses to proceed past those and get to the Unlawful Insurance Act, I believe the court should find that the Craighead case modified the language of the statute to include liability against other defendants in addition to the insurer. If the court chooses to permit that issue, that's complete within the court's discretion after the main ruling. And that, well, we're at 1 minute and 7 seconds. Subject to any questions, I will sit down and conclude the arguments.
I see none.
Thank you, Your Honor.
Thank you. Thank you, counsel. We appreciate your argument. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. The court will stand in recess to the call of the next docket.
All rise.